I'll begin the session by welcoming you all. It will be an open forum. So Albert, maybe I begin. So welcome all. Sorry, I am muted. So welcome all. So I begin with you, Albert. Albert, in your view, I've seen the course outline for probate and administration. Kindly give us the 5 or 4 types of limited grants with a bit with an explanation to each.
Okay, thank you. Kindly confirm you can hear me.
Yes.
The first one, we have the limited branch of letters of administration. These are granted to a person so that they can be able to administer the estate of a person who died without a valid will. Secondly, we have limited grant of letters of administration. Limited grant of letters of administration. These are limited to enable the administrator to institute a suit on behalf of the estate. Then we have limited grant of ad colligenda bona defuncti. These are grants that are limited to collection and preservation of the estate of the deceased only, pending hearing and determination of the succession person. Closely related to the limited grants of ad colligenda, we have the limited grants issued under Section 39 of the Code of Law, limited to collection of assets of the deceased and settlement of urgent debts of liabilities. And then we have, so those are 4. The last one, escaping my mind. We have limited grants of letters of pendelinte, I think something of that sort. These are limited for the agency of the case only. Yes, so I believe I labeled
Albert, have you ever come across grant de bonis non administratis?
Yes, I'm aware.
Tell us its purpose.
Let me give it a try. I believe they are limited. They are granted where the initial administrator has died or is unable to continue with the administration of the estate. So, new grants are issued to another administrator.
Thank you, Albert, for that good trial. We can now read out the answer so that we tick the boxes. We have grant ad colligenda bona. Thank you for muting. Grant ad colligenda bona for collection and preservation of the estate. Then we have grant ad litem for purposes of a suit. Then we have grant pendelinte, this is pending determination of a dispute. Then we have grant de bonis non administratis. This is where you administer an administered estate because the administrator or the executor has died or he has been removed or becomes incapable before completing the administration process. Then we have a special limited grant. This is where the authority is confined to a defined asset or act as the circumstances will permit. But Albert, I can see you have dropped out from the call. So Pluto, now the ball is on you. Kindly listen to this question. If a person who has opted to remain silent or to give an unsworn statement, are they allowed to call witnesses?
Thank you for the question. In my view, for someone who decides to proceed with his trial by remaining silent or otherwise giving unsworn statements, still has the right to call a witness. This is because the unsworn statement, the court will approach it very cautiously, and unless it is corroborated by another evidence, it's only when it will hold water. Therefore, if the accused person decides to give unsworn evidence, he still has the opportunity to bring in another witness who can either swear on oath or give unsworn statement. Thank you.
Okay. Thank you, Pluto, for that answer. Now, for the person who have decided to give unsworn statement, what have they forgone? What procedure will they have forgone by choosing to give unsworn statement?
Thank you once again for the question. When someone decides to give an unsworn evidence in court, they are simply foregoing the aspect of cross-examination by the adverse party or counsel. Thank
Yes.
you.
Hello? Yes. Yeah, yes, nakusikia.
Albert, just proceed. Albert,
I'm waiting for Faulu to communicate. Walisema wataget over.
Last for a few minutes and I didn't hear the answer concerning the grants. Nilidrop off kidogo alafu ndio nimerudi sahihi. Kama nijarudia.
Yes, I can repeat the question.
Yes.
Where the accused has decided to give unsworn statement, do they have the right to call witnesses?
Also the findings on the initial question before I dropped off. We had started by giving the grants and the illustrations.
Oh, yes, I can repeat that for your benefit so that we don't lose you. So you tick the boxes as per the answers you gave. We have grant ad colligenda bona. This is where you correctly directed that you do an application for collection and preservation of the estate. Then there is grant ad litem. This is filed for purposes of institution of a suit or defending a suit. Then we have grant pendente lit, a pending determination of a dispute. And then we have grant de bonins non-administratis. This is where you want now to administer an administered. Maybe Pluto, you can take over as I take this con. Hello? Yes.
Yes, Albert, what Victor is saying is that apart from the limited grants that you have identified, which are ad colligenda bona defuncti, grant ad litem, we have others that include the grant pendelit, which is used to preserve the estate during the pendency of a dispute concerning the validity of a will or entitlement to a grant of representation. Additionally, we have grant de bonis non-administratis, which is issued to deal with the unadministered portion of an estate where the original administrator or executor has died, been removed, or is otherwise unable to complete the administration. Then we have another one called limited grant cessate, which is issued when an earlier grant, such as grant pendelit or colligenda bona, has come to an end and there is a need to continue the administration of the estate before a full grant is confirmed. Then we have another one called the grant durate absentia, which is a limited grant issued when the person entitled to administer an estate is temporarily absent from the jurisdiction and or is unable to perform their duties. And lastly, we have the grant durate estate minority, which is issued when the person entitled to administer or the sole beneficiary of an estate is under the age of the majority and thus legally incapable of performing the duties of an executor or administrator. So those are the different types of grant. Then lastly, we have the limited special grant, which serves the purpose of tackling emergency issues such as paying school fee before the full grant is confirmed.
Thank you, Pluto, for that. I believe, Albert, now that has been clarified. And then I asked Pluto on now the situation that can arise if an accused person decides to give an sworn statement, and he has correctly captured the two angles of it, in that an sworn statement person will still be eligible to call witnesses, and the only thing that they have forgone is the right to be to cross-examine or be cross-examined. So that was the second facet. Then, Albert, I have another question. If you read various decisions emanating from the High Court, there is an interpretive rule used by the High Court in terms of constitutional cases known as reading in doctrine. What is your understanding of this doctrine? The doctrine of reading in.
Hello.
Yes, we can hear you.
Could you kindly repeat the question? Sorry, I'm on transit and it's very noisy.
Okay, let me repeat. There is an interpretive. Okay, sorry. Let me now proceed with Pluto as you arrange. So Pluto, there is an interpretive technique used by the High Court in terms of constitutional cases. This doctrine is known as the doctrine of reading in. What is your understanding of that doctrine?
Honestly, I don't think I can correctly capture that. So I'll just stand guided on that. So pass.
Sir, thank you. So this is the answer. Reading in is a constitutional remedy or technique where the High Court cures a statute's unconstitutionality caused by an omission by adding words or qualifications into the provision so it complies with the Constitution, instead of striking the whole provision down, but only where the court can do so without effectively legislating a new policy. So I believe that is an allowance that has been given to the High Court pursuant to Article 165.3 on the High Court's jurisdiction to determine constitutionality and the jurisdiction to interpret the Constitution. So in doing so, they can use the reading in doctrine. So that one, I believe, we have possibly answered. So Pluto, I can ask you the next question. Okay, I can repeat what I've said. In that, reading in is a constitutional remedy or technique where the High Court cures a statute's unconstitutionality caused by an omission by adding words or qualifications into the provision so that it complies with the Constitution, instead of striking the whole provision down. Okay, but this is to be used sparingly where the court can do so without effectively legislating a new policy. So Pluto is on call. Okay, thank you, Pluto. So I believe now you have captured the doctrine of reading in. You have muted.
Sorry, I believe you said that is where the High Court has the power to interpret a statute by inserting a word that had been omitted, so that to give it a constitutional force or constitutional interpretation or meaning, right?
Yes, that is the answer. That is the answer. Thank you. So, because Albert has still not yet confirmed his position, what is the time limit for instituting a criminal charge? And before you rush to answer, also consider whether there are some criminal offenses where there is a limitation if your answer is in the negative. What is the time limit for instituting a criminal charge?
I wish to answer it in this way, and I'll be specific to something like murder. For murder, the limitation is 1 year in this sense, that assuming the accused person or not the perpetrator of the offense stabbed a victim and the victim does not die within 365 days, then the charges of murder will expire. Therefore, they cannot bring in the charge of murder against the perpetrator. So I believe for criminal offense, they are kind of distinguished, because for murder, it is 365 days. What was the other question, kindly?
Do we have specific criminal offenses that have been provided in the penal code that have time limitation?
Yes, for instance, the number they have stated for murder, there's a time limitation of 365 days.
Okay, thank you for that. Now listen to this. Section 42 of the Limitation of Actions Act, it's titled that exclusion of certain proceedings. And this act does not apply to criminal proceedings or matrimonial proceedings or an action to recover possession of trust land. And now Pluto, the angle of criminal proceedings has been directly excluded from the application of Limitation of Actions Act. Will your answer still be the same?
No.
Why?
Because because limitation of bringing suits is governed primarily by the Limitations of Actions Act, and by virtue of the Section 24 that we've just read, it excludes all criminal offenses or proceedings.
I can hear you have a call. Maybe Albert, are you in a position now to be cross-examined? Albert, are you in a position to be cross-examined?
But you can just ask me, no problem.
Okay. Maybe you can try. I was asking whether there is a time limitation to criminal matters.
Whether there's a time limitation to criminal matters.
Yes.
The general principle is that there is no time limitation to institution of criminal proceedings. That is from the time the commission is allegedly reported to advocate up to when the person will be formally brought to.
What about treason? What about the offense of treason?
To be honest, I'm not. To be honest, I'm not acquainted with that. Perhaps in future. Yeah.
Sir, thank you for your attempt. I'm waiting for Pluto
Right.
to. Thank you. So I'm waiting for Pluto to confirm now his attendance before I give the answers and also hear his input. Pluto, I was asking Albert on whether treason is an exception to the rule of limitation of actions when it comes to criminal proceedings, because you have seen that the same has been limited by Limitation of Actions Act. What's your take on that? Is treason an exception? Before I read out the answer.
Maybe I can just give a reasoning when treason is concerned. The description of what treason is trying to overthrow the government, or thinking, insulting, or actually imagining the death of the sitting president. So if the term of the president expires, in my view, I believe any charge for treason against that, stating that the president is the president whose tenure has expired, are limited. Thank you.
Thank you, Pluto, for that attempt. Albert, do you have an input before I give the answers? Okay, so let me proceed and give the answer. So if you read section 45 of the Penal Code, it says that a person cannot be tried for treason or for any of the felonies defined in section 42. This is why you have concealment of treason, section 43, treasonable felony, section 43A, treachery, and section 44 on promotion of warlike undertakings, unless the prosecution is commenced within 2 years after the offense is committed. So Pluto, you have tried, but you have cornered it to the regime in place. So pursuant to your attempt, you have focused. Okay, Albert, you are talking.
Victor,
okay.
Maybe you can just repeat.
Oh, I can. Good. I can repeat the answer.
But Albert, we give a try. Maybe we can give him the opportunity.
Oh yes, Albert, you can give a try.
Albert, are you there?
No, just proceed.
Okay, so I was reading section 45 of the Penal Code that says that a person cannot be tried for treason or for any of the felonies defined in section 42, 43, and 44.3 and 44, all in relation to treason, unless the prosecution is commenced in within 2 years after the offense is committed. So at least that is the statutory backing that a treason offense cannot be brought after the expiry of 2 years after the offense has been committed. So the exception to the rule is that where a statute has expressly prohibited, then you will not have limitation of actions in criminal matters. So maybe another question is that it can go to Albert. Now, Albert, are you in a position? Because I don't want to incline only towards Pluto for the benefit of everyone. What is your opinion on this question? Do matrimonial properties form part of free property eligible for distribution in a succession proceeding?
Whether matrimonial property
forms part of free property eligible for division in a succession proceeding?
Uh,
That is upon death of one of the spouses.
okay, continue. A bit noisy.
Yes, you are.
Okay, I was saying, can you confirm my
Yes, you can hear you, but your background is noisy. Do you want assistance from Pluto?
I've gotten to somewhere more quiet. Is it still noisy?
Okay. Yes, no, it is not noisy. Now you can try.
Okay,
Is
okay.
matrimonial
I think for the
property?
matrimonial property,
Mm-hmm.
it will depend. If it is property that was jointly held, then the doctrinal survivorship shall apply. So the property will automatically pass to the surviving spouse and therefore not eligible for or not eligible for to form part of the unadministered estate. However, if it's property that was owned in common or commonly owned, then that property will be available for succession to the estate of the deceased.
Thank you, Albert. Those are the principles that we were expecting to hear from you, and you have correctly appreciated the same. Now, Pluto, back to you. You have seen the recent finance bill of 2026. Maybe you can give us two takeaways from the finance bill, what the same is proposing to bring on board, and give also the process of the lawmaking procedure in Kenya, so that we appreciate by the fact that you not only know the contents of the finance bill, but you also understand the procedure that this finance bill is going to be applicable to. In a summary.
Thank you. I'll start by giving the lawmaking process, then conclude by giving the true takeaways or important clauses that have been started in the Finance Bill 2026. So to start with the lawmaking process, ideas are collected and brought into the parliament where they are reduced into a bill or writing. Then we have the first reading where the bill is read to the members of the public, no, members of the parliament, and they give their views from the first reading. Then there is the second reading, when the bill is now again read to the parliament, and considerations from the first bill have already been effected to the now being to the bill which is now read at the second time in the parliament. The bill is then published in the Kenyan Gazette and nationwide newspapers for public participation purposes. We now have the committee stage, wherein the committee of the parliament is formed to give their opinion or views regarding that bill. After that, we have the third reading, where the views of the public and the views from the committee stage are put into consideration, and an amended draft of the bill is now voted on. If the majority of the parliament votes yes, the bill proceeds to the president for vetting. If the president signs it, vets it into it becomes a law within 7 days. The president still has the power to vet it but with to reject it with recommendations back to the Parliament, either to delete some clauses or change on something, and then it is brought back to the President for vetting. For instance, in the 2024 Finance Bill, the President signed the Finance Bill, but with the recommendation that the Parliament deletes all the clauses. That's why it never became effective. However, another thing very important to point concerning bills is that we have two different types of bills. If a bill is a money bill, it must proceed to the Senate for assessment or actually voting, another whole process on the bill to become a law, if it touches on the finances of the country. If it's not a money bill, there is no need for it to go through the Senate. Lastly, on the two important clauses of takeaways from the Finance Bill 2026, we have this clause where it is where the bill introduces the thing that all also, I think but we have this another clause which increases the past.
So thank you for that. Pluto, you have greatly attempted the procedure of how the bill is will undertake until publication or enactment into the law. We have the first reading. The source of the document is a publication by the Kenya Parliament, so it has credibility. So first reading, the bill is introduced in the House for the first time by way of reading the title of the bill by the clerk. There is no debate or voting arising at this stage. So that is the key takeaway in this part. And then, still in first reading, the bill will be given to, will be submitted to the relevant departmental committee for consideration. Okay. Then we go to the second reading. This is the debate stage. Okay. The debate generally follows the moving of the bill by the sponsor and its seconding by any member. So this is where they vote. Then you have committee stage. This is where the committee, the whole house turns itself to a committee. Okay. And in this situation, the house resolves itself into a committee which is comprised of the whole membership of the assembly. The committee is presided by the deputy speaker. I'm looking for the key takeaway is that the guiding principle is that the committee should make such amendments in the bill as may seem likely to render it more acceptable, practical, or efficient without having to severely deviate from its primary principle and objectives. So generally, this is the in quotes where Pluto you confused with the third reading, because from first reading you go to second reading, then to committee stage where it is debated or analyzed by the whole house being a committee. Then you have the report stage. So the parliament document says that we have the report stage before going to the third reading. Upon resumption of the house to plenary, the report is made to the house, which following a procedural motion votes on it. At this stage, any member may with reasons also move the house to resolve itself into a committee again to reconsider any specified clauses of the bill. This is known as recommittal. So don't worry about this document, I'll share the same in the group, but we must outline the key steps. So we have the report stage, then we go to the third reading. The third stage of the passage of the bill is through the house is the third reading. No further substantive amendments are taken up in this stage. Though drafting amendments and renumbering of clauses may be accepted, generally there is very little debate during the third reading and a final vote is taken during the third reading. So this is where Pluto got it right, that after the third reading you go to the presidential assent, and the president can either assent or refer the bill back to the house with a memorandum outlining his reservations. Okay, so maybe another point where Pluto said that a money bill may only be introduced in a certain house. These are the key details emanating from this document, is that any bill may originate from the National Assembly. 2, a money bill may only be introduced in the National Assembly. C, a bill not concerning county government is only considered by the National Assembly. And D, a bill concerning county governments may be introduced in the National Assembly or the Senate. Okay, so those are the key takeaways that you must grasp at this stage. Then Pluto, I asked you on various proposals that can be seen in the new Finance Bill of 2026, and we can summarize it generally by attempting the one that you had tried to talk about, real estate and rent. So the bill proposes to increase residential rental income tax from 7.5% to 10%, but it exempts real estate investment trust, also known as REITs, from capital gains tax and stamp duty. Okay. Then we have mobile phones, where we shift 25% excess duty from the point of importation to the point of activation. This is the boost to M-Kopa phones, because M-Kopa phones, this is where you pay lipa mdogo mdogo. They are being charged 25% of excise duty, and at the same time they are also charged at the point of activation. So these are relief to them. I had Honorable Bandi trying to explain the same, in that the shifting of 25% excise duty from the point of importation understands that you could not have made a sale. So at the point of activation, where the customer has purchased this phone, this is where, once the phone has been activated, you will submit 25% excise duty to the KRA officials. Then you also have another arrangement. We have reinstatement of the tax amnesty program for liabilities up to 31st December 2025, but it will be valid if principal is paid by 31st December 2026. This is a bit technical at our level, but I can look for a simple one, where we have income tax filing. It shortens standard filing window from 6 months to 4 months after the financial year end. So this is used to tighten compliance, where taxpayers must file earlier, and individuals or firms with nil returns must file within 1 month. So those are the key takeaways that you can tell the panel, and they will see that you have duly analyzed that document. So that was it as far as the current affairs is concerned. So I can go back to Albert. Now you can confirm that you have a stable background.
Yes, it's a bit stable.
Yes, we can hear it is very stable. So Albert, this is emanating from the Law of Probate Act. So I want you to attempt this angle, in that there is a husband and a wife. The wife dies, okay, and then she decides to appoint various trustees to govern the immovable properties on behalf of the kids who are, let's say they are minors. So that's why you are appointing trustees. So in this situation, this lady, this husband decides now he is going to gift these kids, and in the process of gifting these kids, he decides to also write a will, but this will is giving a property to an outsider, okay, and some gifts are also given to outsiders. So what is the general law when it comes to gifting free property in such situations? Can you gift away a property to outside beneficiaries that are not forming part of the estate? Maybe Pluto, you can assist in framing the question. Maybe I could have omitted some aspects of the same, but I know you clearly understand this point.
No need for reframing. I've already understood it as it is. I think from the facts, the main issue is whether a person can freely dispose of free property to parties that are not relatives through a will. Right?
Yes.
Yes. And
Before
my answer
you proceed,
is yes.
is this property actually free property? So maybe Victor can just reframe the question and tell us whether before the wife passed on, whether the property was matrimonial at that particular time, or the husband, who is not the widower, attained it before marriage, so that we can distinguish whether it's property.
Okay. Let's say it is matrimonial property.
Okay. The property is matrimonial.
Yes. Yes.
And now, okay, when it's matrimonial, I'm assuming the husband now did succession, and part of that property devolved into himself absolutely, and then he now gets the capacity to gift out part of that will through part of that property through will. Now, my general answer was that every person or individual has the right to testamentary freedom. That is to say, they can give out their property as they desire in their wills, and that will only take effect upon their death. So nothing in the law of succession bars a person from giving out any of their properties to any person, so long as the will is valid and has attained all the requirements of a valid will. So whether the person is a relative or not, so long as a person had the capacity, and in capacity by this sense, we mean first capacity to the property itself being gifted out. If the person had capacity, that is, it was free and fully owned and other persons, then that property can freely be gifted to any person in their will, and so long as the will also meets all the elements required for a valid will.
Yes. Thank you. Pluto, your hands are up.
Yes, sir. Just to reframe the question in another way. So Albert assumed that the husband, these are completely different set of facts, but under the same topic. Assume that the husband acquired some property during their marriage, and the property was registered in the name of that husband. Then it happens that sadly, the husband dies. Now, from our Law of Succession Act knowledge, we understand that the lifetime interest of this of the estate of the husband, of the mzee, the late mzee, devolves to the wife. That is the lifetime interest. So, can the wife, now the widow, gift out that particular property to outsiders? And whether, number two, the wife can actually, not the widow at this moment, can actually write a will and maybe will to different people, or maybe will to her own children. Thank you.
Okay, thank you for that question. It raises some very pregnant points. So I'll start addressing one by one and see if I can conclusively dust them off. Allow me to start with the issue of life interest. This concept initially meant that where a spouse has died and there was matrimonial property, the widow would usually get life interest to that property alone. That is to say, she was allowed to utilize it and use it the way she would like, so long as it is during her lifetime. So the widow will not get absolute ownership or absolute interest of the deceased property or spouse. Now, in 2023, this decision was, this rule was declared unconstitutional in the case of Repos International versus Attorney General by the Honorable Justice Mureithi in Meru. So, the net effect of this declaration of constitutionality of the life interest is that the rationale behind it was that if the widow will be given life interest only to property left by their deceased husband, the same should apply also to widows because of the general rule of equality. So it should apply in equal measures. Now, moving to the other limb of that question, whether this widow could now will out. Okay, that was the last question. The second question was whether this widow could now dispose of this property to other third parties during her lifetime. The general answer is no. However, it is not absolute. It is subject to some exemptions. The widow can actually dispose of that property so long as they get consent from court and consent from the adult children of the deceased spouse. So under those circumstances, if the court has consented, they apply to court for the disposition of that property. If they get a court order, they are granted leave to do so, they can. And also another requirement is that the children of the deceased who are within the age of the majority should consent. And then the last question was whether the deceased, whether the surviving spouse can will out that property. Now, the general principle of life interest, I think, in my view, I stand to be corrected. If it only vests upon you during your lifetime, it means then once you die, the estate devolves back to the deceased husband who had died initially. And then for it to succeed thereafter, it means the children now of the deceased should now apply for succession such that they can get absolute ownership or title to such properties. And therefore, it will be a very tricky situation for someone to will out properties which they have life interest only. Because I'm imagining a situation if, you can, the general rule is that you can't pass a better title than you have. So if you have life interest, then you give it to someone. Will it mean that when you die, even the property the effect of that? So I wanted to learn from you. Thank you.
Thank you, Albert. Thank you, Albert, for that good attempt. Pluto can try to clarify as I read out the marking scheme.
Okay, Albert, I just wish to take you back, kidogo. I asked the question on gifting. Can now the surviving spouse gift the property to outside outside members, that is members outside the family, other than the beneficiaries, other than the children? Can the surviving spouse gift the property to, say, neighbors? That was the question that You talked about disposing, but I asked about gifting. Gift inter vivos, to be clear.
Oh, gifts inter vivos. Okay, the concept of gifts inter vivos again is dependent on the rights of this surviving spouse, because as I've said earlier, you see, you cannot whether gifting or disposing of, you see, you are dealing with a property. First, we must have to address the issue of capacity. First, what capacity or interest do you have over that property itself? That's why it is taking us back.
Albert, you have disappeared. We can't hear you. Maybe Albert, you have lost
life interest. Now, where the law prescribes that, in view, it will take us back to the issue of capacity to do that. Even though the concept of gifting inter vivos itself, you are not.
Albert, we are losing you. It looks like your Wi-Fi connectivity is low. Maybe I can proceed and read out the answer, because I have a question for Peter Ikua arising from that trajectory. But it is a very simple yes or no answer. So that I want to read out the act, then read out the interpretation of that section in a layman's language. And then you tell me whether I have interpreted it correctly, so that you get the gist of why.
Let's say if it's a property.
Albert, we are losing you. Kabisa, your Wi-Fi is appearing to lag behind.
Oh, you've not been hearing me?
Yes, you are disappearing.
Yeah, sorry. What is the last thing you had?
I was saying that I can read out the exact provision that we have extracted that question from.
Okay.
Then we read the layman's interpretation of the same. Then I ask Peter Ikua a question arising from another angle, but very technical. So maybe I read section 35 of the LSA, Law of Succession Act, where intestate has left one surviving spouse and child or children. So I want you to hear attentively, because I'm already reading subsection 1 and subsection 2 only. Subject to the provisions of section 40, this is where we have polygamy, where an intestate has left one surviving spouse and a child or children, the surviving spouse shall be entitled to 1. The personal and household effects of the deceased absolutely, and a life interest in the whole residue of the net intestate estate, provided that if the surviving spouse is a widow, that interest shall determine upon a remarriage to any person. This is the article. This is a section that, Albert, you have correctly gotten that it was declared unconstitutional for gender bias. Then 2, we are very, very purposive in reading subsection 2. A surviving spouse shall, during the continuation of the life interest provided by subsection 1, have a power of appointment of all or any part of the capital of the net intestate estate by way of gift taking immediately effect among the surviving child or children, but that power shall not be exercised by will nor in such manner as to take effect at any future date. What is the general interpretation of this provision in a layman's language? Section 35(2) means that where a person dies intestate without leaving a will, leaving a spouse and a children, or a child or a children, the surviving spouse who holds a life interest in the estate may, while that life interest is still running, give out some or all of the estate's capital to any of the children as an immediate gift, i.e. transfer it to them now. The spouse cannot do this through a will and cannot make a gift that only takes effect later, for example, on the spouse's death or on a future event. This is the point that we are saying, that this provision applies to beneficiaries only. You can't use it outside of the people who don't form part of this estate. That is what Pluto was trying to also emphasize. Maybe Pluto, you can clarify whether I've gotten the correct interpretation of the same and whether we are on the same page.
Yes, I believe you have read the right thing and you have interpreted in the right way. And just to dodge it back to Albert, is your position still the same, or what do you think the answer could have actually been? You can better it or still maintain it.
Sorry, I dropped off a little bit on subsection 2.
Okay, Albert, maybe you can just note. Yeah, subsection 2 states that the surviving spouse shall have the power to appoint section of the property to the surviving children by way of gifts, provided it takes effect immediately, but not on a future date. And additionally, provided that he or she doesn't do so by a way of a will. Basically, it means that the surviving spouse has the power to gift part of the estate to the surviving children or beneficiaries, provided the gifts will take effect immediately, and she can do so only by the way of gift and not wills. So, I think we can hear now from Peter on the position of the question that I had asked, because I believe it was in the platform. What could be the perfect answer, Mr. Peter? Peter seems lost, so maybe Albert, back to you once again.
Okay, now in light of that reading, I don't know whether I'll fully change my answer or maybe to some extent, because my understanding is that the surviving spouse will have power to gift the children so long as the gift shall take effect immediately. And now, to be specific, your question was asking on third parties who are not children or relatives. Then I will now try to find out whether those third parties fall under the definition of the children or beneficiaries. So for children, there is a wide definition of children. Children could mean many, either biological or adopted, or either people who were taken by the deceased as his own during their lifetime and whom they have equal or whom they rank with equal rights with the biological children of that sort. But your question was completely on neighbors. Ama?
Yes, Albert, I asked on neighbors.
On neighbors.
I asked on whether
the neighbors are excluded. They are excluded.
And then I asked whether the spouse can will the property to the surviving children.
Oh yes. Okay, then my answer also will change on that. On that part, the spouse cannot will that property to the surviving children.
Thank you, Albert. I believe that's the point that I was trying to drive. Section 35.
Oh, it's section 35 of LSA?
Yes.
Thank you. I'll have a deep reading on it. Thank you.
All right, back to you, Victor.
Thank you, Pluto, for that. Peter Ikua, can general damages be awarded in a case for breach of contract? Give reasons. Peter, are you in this meeting? Okay, I can turn this question to Dust Albert. Now it is Pluto. Pluto, Can general damages be awarded in a case for breach of contract? Give reasons. If not, are there any exceptions to that rule?
Thank you. I believe for contracts, once one party defaults, the other has equitable remedies, which include specific performance.
Hello?
Maybe the deposit will be withheld by the seller. And to some extent, I believe there should be general damages in this sense. That assuming, or I can just give an example, where the buyer of a certain parcel of land has decided to default the agreement, and the seller could have used that particular farm or parcel of land in farming. He has then undergone a loss which cannot be quantified. A loss which is not monetary form, but can still be quantified. For instance, he should have planted in that particular farm or plot and obtained a certain produce. Therefore, my answer would be that for breach of contracts, general damages are payable.
Pluto, that is well captured. So the answer is generally no. Kenyan courts do not award general damages for a pure breach of contract because contractual damages are meant to be compensatory and are normally quantifiable through special, liquidated, and nominal damages. Generally, not at large, but exceptionally, yes. General damages may be awarded where the breach is attended by oppressive or vindictive conduct or other special circumstances the court specifically justifies. This was settled in the case of Sundowner Lodge Limited versus Kenya Tourist Development Corporation 2023, a decision that emanated from the Supreme Court. Okay, because it said that the Supreme Court held that the issue of the availability of general damages as a remedy for breach of contract is well settled in Kenya. The Court of Appeal, so it gave now the deeper analysis of why it took that position. So I highly urge you to read the case of Sundowner Lodge Limited versus Kenya Tourist Development Corporation 2023, where the general rule is that you not get general damages for a pure breach of contract. So maybe Pluto, that was to clarify on your previous attempt. Thank you. So Pluto, can a man apply for alimony? See Pluto, Peter appears to be joyriding and dodging questions. Okay, Albert, can a man plead for alimony?
Can you hear me?
Yes, we can hear you.
Yes, indeed, a man can plead for alimony. I don't have a case law on my feet, but looking at the general application for alimony, if the man can actually prove that during the subsistence of the marriage, he used to depend on the wife or former wife for their upkeep, and the former wife actually did take responsibility by providing that upkeep, then in that instance the man can plead alimony.
Thank you for that. And the enabling provision is section 77. Yes.
Nasikia mlikuwa mnanitafuta. Swali ni gani?
Yes.
Ya alimony.
You are no. That one Albert has correctly scored. No. You are next. You are answering the next question. So
Okay.
Albert has directly scored the same. Eh? Wapi? Siko sure. Nairobi to Embu, eka 4 hours. Yeah. So, I was giving the enabling provision, section 77 of the Marriage Act, where the court may order payment of maintenance to a spouse or former spouse during matrimonial proceedings, on or after divorce or even separation. This is pursuant to section 77 of the Marriage Act. So, Peter, I was coming to you. In the KDF Act, section 13, the accused person shall not have the right to object to a prosecutor or an officer under instruction. Article 25 of the Constitution of Kenya, it says that rights that cannot be limited in any manner whatsoever, including the right to a fair trial. How will you reconcile these two provisions?
Thank you very much for the question. And I'd like to start by saying that the Constitution of Kenya, it is the supreme law of the land. And when you look at Article 2 of the Constitution, it is provided that any other law that is repugnant to justice and immorality
Hey Peter, kwani you're losing you.
Kuna venye net yangu kidogo ilikuwa kiasi, but nilikuwa nasema what I was saying is that the Constitution is the supreme law of the land, and any law that goes contrary to the Constitution, I'm like, then the Constitution is deemed to be higher. So when a statute which is below, when you look at the hierarchy of the laws in Kenya, a statute is deemed to be on the lower echelon, or the lower cadre from the Constitution. And when the Constitution provides that the rights that they cannot be limited, they include the right to a fair trial, then a statute cannot then come again and then try to limit that right. And when you look at Article 24 of the Constitution, on the limitation of the rights, and they say that these rights are not absolute, and Article 24. And Article 24 goes ahead and says that the rights that cannot be limited, they include the rights under Article 25. Therefore, it shows that that section of section 13 of the KDF Act, then it should be done away with. I think that is a law that should be taken back to Parliament for amendments, because then it is infringing on the soldiers' rights. Thank you.
Thank you, man, Peter. You have gotten it, but you have used a lot of definitions. I have said that in the previous question, there is a doctrine of reading in, where you are allowed as a High Court judge to interpret a provision of the Constitution to see the constitutionality element of it, and this is one of the situations where you can apply the interpretation of Article 25 into this situation, where you reconcile them by construing the KDF Act closely and narrowly. If it's truly the challenge to the prosecutor, treating it as unconstitutional, therefore you invoke Article 25C and give various reforms. So you have correctly captured the same. So maybe we can end the session because it is 7:20 with various two or three questions to finish the session. Pluto, you are an adept researcher when it comes to the law of extradition procedures. And you have even mentioned to me previously that you have analyzed the extradition and that name Contingency Act. What is the procedure for extradition procedure in Kenya?
Thank you once again. I believe I should not be using the words I believe. So, the extradition procedure is basically where a foreigner has committed an offense which is punishable in Kenya or provided for as an offense in Kenya. The act or omission is provided for as an offense within the jurisdiction of Kenya. Therefore, due to diplomacy and international relations, that foreigner is then supposed to be charged or tried in their country of origin. Basically, we have two procedures. The first procedure is when the magistrate now determines whether this particular offense is actually extraditable. One, whether this is an offense which is chargeable in Kenya. At that particular point, the magistrate's duty is limited only to determining whether that particular offense or allegation or charge is an offense within the jurisdiction of Kenya. At that point, the magistrate is not supposed to try guiltiness of that particular foreigner. Then it's only after the magistrate or the trial court has determined that that allegation, that act or omission is punishable in Kenya, that they certify him ready for extradition. Then now hands over to the cabinet secretary for international relations for extradition. With that is governed by section 76 of the, I can't remember the name of the exact act, but its contingency is something, yeah. So basically that's the process of extradition. And I'll be guided for any steps that I've missed.
Thank you. You have proved that you have mastered the same. It is Section 8 of the Extradition and Contingent Foreign Countries Act, Cap 76. Okay, so the procedure is that there is the request being received by the executive, who is the AG, and it is transmitted for action. It is transmitted to who? To the DPP. So the DPP will arrest, will issue arrest orders, and there is a first appearance before a magistrate. So Pluto, in your answer, you had omitted the first three steps, and then you jump straight to the magistrate. A committal hearing before magistrate, you have correctly stated that the magistrate will not determine on merits, but they will check dual criminality or extradition offense. It must be an offense in Kenya, and then check authentication and whether there is sufficient evidence that will justify committal if the conduct was prosecuted in Kenya. If committed, custody pending surrender warrants by the cabinet secretary, and person may move to habeas corpus to challenge within the statutory window. If no successful challenge is received, then surrender is executed. So Pluto, another aspect that you had omitted is where we have the right of this person to challenge the decision coming from the magistrate through the statutory window timelines. Then that will be it. You can read through that act, so that will go to the final question that will be tackled by Albert Charo, and that will mark the end of the session today. Albert, what happened? Oh yes, you can. Yeah, you can close the session because Pierre Albert has been extensively grilled together with Pluto. What happens, Peter, when a widow has applied for letters of administration, but they have no one to guarantee them? So, sorry, what happens when a widow has applied for letters of administration but they have no one to guarantee her? Moto.
Thank you.
Sorry, I can repeat the question.
Thank you very much.
Repeat the question.
Thank you very much.
Have you heard the question?
I've heard.
Okay.
So when a widow wants to get what we call the letters of administration, and I presume this is after the death of the man, of the husband. So what the widow will do is that the widow should first go to the chief, and this is provided under section 50 and under the law of succession. The widow should first go to the chief's office for identification, so that the chief can indeed give the widow some letters introducing the widow and saying that indeed the chief knows that she is the widow, and she was the wife to the deceased. Then after that, then the widow should should then again go to the court and petition for what we call the grant of letters of administration, so as to ensure that the property of the deceased it is well distributed. So the position is the widow should first go to the chief first, because that is the first point of order.
So thank you, Peter, for your attempt. And maybe you can read out the answer. If the widow cannot get the two sureties required under Rule 29 for security purposes, the court will not issue the full grant on the usual administration bond. Instead, she should apply for the court to 1. Dispense with the security requirement, or 2. Issue a limited grant, or 3. Appoint a co-administrator, being an alternative security arrangement. Because if you read Rule 29 of the Probate and Administration Rules, it says that the court may require to be satisfied as to the solvency of an administrator. Okay, so those are the various elements that you can try to use in order for the court to be satisfied to the solvency of your administratorship. So in particular, where even children will be involved, remember you can't do anything where children are involved without co-administratorship in any position. So maybe in case Pluto, you I've told you that what happens when a widow has applied for letters of administration but they have no one to guarantee her. Okay, so I was testing on the rationale of why courts require a guarantee. So the reason why courts require a guarantee is because of Rule 29, that courts may require to be satisfied as to the solvency of an administrator. So the various practical solutions I was giving you is that the widow can use them because the court will not issue the full grant. That is the law. Okay, so you have to use, maybe you request now for a limited grant, or now you do an application to appoint a co-administrator. Remember, the courts have powers to appoint a public trustee. Those are the angles, so that the court will be sure that you are not going to be insolvent, because once you are insolvent and you are an administrator, that automatically says that you are going to misuse this estate of the deceased person. So they must test the solvency of your capacity. Yeah, that was the rationale. Okay. So I believe I have answered the question. Remember, Peter guarantees Form 56, 57, or 58, as the case may be. So that was a tricky one because people never attempt to ask the rationale of having these guarantees. They only follow us templates that are used in practice. Hapo tuko sawa? You can read Rule 29 of the Probate and Administration Rules. It is a lengthy one. And I may give the full rationale of why it is required. So up to this point, because it is 7:30, the session is marked as closed so that we move to other agendas. Thank you for your participation. Sawa sawa.